Hello, everyone, and greetings from Geneva. It's my pleasure to welcome you on behalf of the United Nations Institute for Training and Research and the University for Peace to this open webinar on the role of international courts in times of conflict. Kindly allow me to introduce myself as your moderator. My name is Shayna. I'm working with the International Law Program at UNITAR's Division for Multilateral Diplomacy. I'm delighted to be joined here by our esteemed experts in international law, Dr. Marjolein Schaap and Dr. Stephanie Lau-Shelu. Dr. Marjolein Schaap is an assistant professor at the Department of International Law at UPeace. Marjolein has a successful and very diverse academic background, with her principal areas of research and study being in public international law, human rights law and the accountability of international organizations, and international environmental law. Also joining us today is Dr. Stephanie Lau-Shelu, who is a professor of European law and reform, head of the School of Law and University Chair for Research and Innovation at the University of Central Lancashire in Cyprus, and of course, visiting professor of the Rule of Law at UNITAR. She is a registered mediator in commercial disputes in Cyprus, and in 2022 was selected by the European Commission as an arbitrator and trade and sustainable development expert. She specializes in fundamental rights in context at the national, European, and international levels, and is a rule of law expert on sustainability of rights and systematic challenges to justice in Europe. So please join me in your own ways at welcoming Marjolein and Stephanie. So very soon they will begin their presentations, after which you'll have the opportunity to ask them your questions during a quick Q&A session. So during the presentation, you may kindly use the Q&A function on your screen to write us your questions, and I will do my best to make sure that we read out as many as possible at the end. But before we jump into that, this webinar is part of a larger series called the Make an Impact webinar series, which is a collection of free online events presented jointly by UNITAR and UPeace. Each session will feature experts in their respective fields discussing some of the most pressing aspects of law, diplomacy, and the UN's work to advance the SDGs. So I invite you to check those out and stay tuned for the upcoming sessions in this very exciting series. UNITAR and UPeace will also be running a Master in International Law and Diplomacy. So we kindly ask all interested applicants to visit the UPeace website or scan the QR code to find out more about the application process. These are the application deadlines and start dates, and the program will be offered either on-site, online, or in hybrid modalities. We would also be delighted to welcome you to our new Master in International Law and the Settlement of Disputes. Again, please take note of the deadlines on the screen, visit the UPeace website, or scan the QR code. Information on these programs are also readily available on the UNITAR website, or we invite you to ask your questions at admissions@upeace.org or info.ilp@unitar.org. And this year, I'm excited to announce that we will also be able to offer the Pura Vida Fellowships for potential participants from LDCs and small island developing states. So again, please email us for more info on that. And without further ado, I'm pleased to give the floor to our first speaker, Marjolein.
Thank you so much for having me. So let me first introduce myself a little bit on what I do here at UPeace. So I'm a resident assistant professor, which means that I teach both in the program of international law and diplomacy and international law and the settlements of disputes. In that, what I do is I teach, amongst others, the courses transnational adjudication, international environmental law, and alternative dispute resolution. Today, I want to focus with you on the issue of the role of international courts in conflicts by utilizing the lens of international environmental law. I will first briefly explain the general role of international courts and how these courts may be utilized by parties to a dispute. Thereafter, I will introduce the triple planetary crisis that we're facing right now, why time is of the essence to act for the entire society, and I will explain how international courts have become vehicles for systemic change. As a point of departure, we should keep in mind that the peaceful settlement of disputes is a cornerstone of the contemporary world order. We have here the diplomatic means of settlements of disputes. We think here of negotiation, good offices, mediation, inquiry, and conciliation. And we have judicial settlement, where we're focusing on today, which is both arbitration and adjudication. International law has played a critical role in resolving conflicts between nations and in promoting peace and stability. It provides a framework for conflict resolution through various mechanisms, such as, for instance, the International Court of Justice. Now, what am I referring to when I refer to the issue of international courts? International courts or tribunals operate within a decentralized system of international law. What does that mean? That means that each state come together and agree to which treaty they want to be party to, and they agree on what rules apply to them, in addition to those general rules that apply to all, as for instance, customary international law. States are all sovereign equal. It doesn't matter what's the size of territory there, or how small the state is, or how big or wealthy the state is. Under international law, in principle, all states are formally sovereign equals. International courts, while they can issue binding decisions, they do not have any means of enforcement, except for the few examples there that we have in the Council of Human Rights courts. That is a main challenge for these courts in ensuring compliance and enforcing international law. So what we've seen is that international courts may influence conflict situations in various ways. And think there of precisely the decision, why would a state decide to no longer go for the diplomatic means of settlement, as for instance, negotiation or mediation? Why would they resort instead for adjudication, for litigation? It could be seen as a way, in international courts can be used as a way of de-escalating in conflict. It can be also used in a way of addressing certain power asymmetries that exist. So in a negotiation procedure, if you have a very powerful state, and think there in comparison, for instance, with a small island state, you're not at equal par. So in a negotiation proceedings, you would not be in a similarly in equal par there as well. While when you would initiate a case at the International Court of Justice and the court has jurisdiction and has the competence to deal with it, you're both similarly parties to the conflict and parties to the dispute at hand. And it can level and it can address certain power asymmetries there. It can similarly play a role in consolidating positions in a conflict resolution, or be dealt with in addressing one stage of a more extensive conflict resolution process. Now, let's make it more concrete. What do I mean with this? How does this relate to issues of climate change? So why am I focusing on climate change litigation? First, let me explain the triple planetary crisis. It refers to three main interlinked issues that humanity are currently facing: climate change, pollution, and biodiversity loss. Each of these issues have its own issues and effects, and each issue needs to be resolved if we want to have a viable future on this planet. Climate change has been deemed as the most pressing issue facing humanity today. In simple terms, climate change refers to long-term shifts in temperature and weather patterns that in the long run will completely alter the ecosystem that supports life on the planet. Human activities are the main drivers of climate change. Climate crisis is getting worse, it's not getting better. Every year, the impacts of climate change are getting more intense. Every year, hundreds of millions of people endure increasingly regularly extreme weather events, taking away livelihoods and lives. As said by the UN Secretary General in 2022, we are in the fights of our lives and we are losing. The warming of the planet and the resulting changes to natural environment pose numerous threats to humanity. There's an increased competition for resources like fertile land, fresh water, and it's already disrupting societies and uprooting entire communities. It exacerbates current conflicts and it fuels new ones. The UNHCR, for instance, notes that refugees often fleeing conflict are severely affected by climate change. Displaced individuals face compounded challenges from both conflict and environmental degradation. Fragile regions experience increased food insecurity, urbanization, and competition for water due to climate change. Land degradation and environmental exploitation combined with climate change worsened already difficult situations. 90% of refugees come from countries severely impacted by climate change or with a low capacity to adapt. Small island states are under direct threat to be submerged. So against this background, what does international law do? So we do have legislation in place. We have what is called the Paris Agreement, and we have the UN Framework Convention on Climate Change as its main conventions. These conventions set out outer parameters, the minimum goals as to what is to be achieved and to be done to address climate change. But it leaves it to each state how to do so and how to implement it. As a point of departure, the Paris Agreement's central aim is to strengthen the global response to the threat of climate change by having agreed of keeping a global temperature rise this century well below 2 degrees Celsius above pre-industrial levels, and to pursue efforts to limit the temperature increase even further to 1.5 degrees Celsius. The UN Intergovernmental Panel on Climate Change indicates that crossing this 1.5 degrees Celsius threshold risks unleashing far more severe climate change impacts, including more frequent and severe droughts, heat waves, and rainfall. To limit global warming to 1.5 degrees Celsius, the greenhouse gas emissions must peak before 2025 at the latest and decline by 43% by 2030. The Paris Agreement requires all parties to put their best effort forward through what they call nationally determined contributions. What are the national plans for mitigation and adaptation of meeting this temperature threshold? But the current climate policies are far behind what is needed to keep global temperature below the 1.5 degrees threshold. Extreme weather events and searing heat is already baking our planet there. People are increasingly thus turning to courts to combat the climate crisis and to hold governments and the private sector to account, and making litigation a key mechanism for securing climate action and promoting climate justice. International courts are thus utilized to change the dynamic of the fight against climate crisis and to ensure climate justice for all, which is where we're focusing on today. So courts have become the new frontier. Climate change litigation has more than doubled in the last 5 years. It's now considered to be a vital tool in delivering climate justice. There have been legal actions have been brought in 65 different bodies worldwide: international, regional, national tribunals, quasi-judicial bodies, and other adjudicatory bodies, including, for instance, special procedures of the UN. Climate change litigation allows stakeholders to address inadequate responses by government and the private sector to the climate crisis. It allows it to seek to compel more ambitious mitigation and adaptation goals. However, states and companies also use it for the contrary goal, to challenge climate regulation and to reduce climate ambition. The IPCC's sixth assessment report stated that climate litigation had, in fact, influenced the outcome and ambition of climate governance. And the IPCC similarly said that climate litigation has become an important avenue for actors to influence climate policy outside of the formal UN Framework Climate Change Convention. So think outside of the COPs that we're seeing always online on whether we are agreeing on phasing out fossil fuel or not. Successful climate change litigation cases have motivated similar cases being filed in other jurisdictions. We've seen that the various courts, whether at the domestic level or at the regional level, for instance, the Council of Human Rights Courts, that they are increasingly finding strong human rights linkages between the climate change crisis and how this interferes with respective substantive human rights standards. As a result, this leads to a greater protection for the most vulnerable groups in society and an increased accountability, transparency, and justice, compelling governments and corporations to pursue more ambitious climate change mitigation and adaptation goals. Because what do we have and what do we don't have? We do not have currently any international court that has the mandate solely to deal with issues of international environmental law. We currently do not have any international environmental law treaty that has a strong enforcement mechanism. So as a result, we rely on the courts precisely to guide us there and to set those further stronger parameters. Precisely because of the framework type conventions that we have, that there's a lot of leeway for states on how to achieve certain results. So climate change litigation is a frontier solution to change the dynamic of the fight. It changes who goes to court on these particular issues. It moves it away from an interstate dispute. And it's now the non-state actors, the individuals like you and me, the youth, the women, the indigenous people, the minorities, the elderly, that are going to court to combat the climate crisis and to hold governments and the private sector increasingly to challenge them and to hold them to account. So what have we seen, for instance, on how it's being used? Well, we've seen that small island states, SIDS, are using international courts as a way to level the playing field, to empower them. Because of the challenges that we have in the context of climate change and the lack of clarity that we have on the scope of legal obligation, how to attribute, for instance, the causes, who is responsible for climate change. We know it's primarily the global north that have been most responsible for the amount of greenhouse gas emissions that we have right now. But do we need to be able to pinpoint who it is exactly? Do we need to show what is the level of causation there, to whom it can be attributed, what can be asked of remedies? There's a lot of unclarity there. And the ones who are affected the most are the most vulnerable states, like the small island states. Because of the challenges that it has to start this case at the international level and start a case directly against the state, small island states went on a different strategic direction. They asked for an advisory opinion of the International Court of Justice and an advisory opinion of the International Tribunal for the Law of the Sea. If time permits, we will talk a little bit further about it at the end of these slides. Similarly, climate change litigation, strategic litigation, has been used particularly by those without a voice or marginalized voice in a domestic context. They use the courts to get the governments to act. Think, for instance, in particularly of youth. We have the Saatchi case at the of the Committee of the Rights of the Child that was initiated by children there, saying that governments, particularly global north governments, need to act to do more to mitigate and adapt to the climate change situation as it affects directly their rights. We similarly have Duarte Agostinho versus Portugal case that tomorrow, the decision will be rendered by the European Court of Human Rights. And we have the state of Montana case, a very interesting case in the national context of the US, where the youth have initiated this case against the state of Montana, saying that the lack of action results into a violation of their right to a healthy environment. Similarly, the cases have been used, and court cases have been used to clarify legal obligations for government on international environmental law. You see, we are by now aware that international environmental law has quite racist and colonial underpinnings. We are aware that there is a massive gap between the global north and the global south there. And where this is most visible is precisely in the different level of responsibilities that should be there in the context of climate change. Global north countries have been the main responsible for causing climate change. So if we would say that everyone needs to reduce by 30%, it is not really fair, and it doesn't apply there to the respective responsibilities that global north countries should have. But identifying what that fair share is hard. We have only the general requirement of taking it into account of the common but differentiated responsibilities in the agreements. Through the courts, this fair share is further shaped. We have, for instance, Supreme Court of the Netherlands, who said in 2019 that the Netherlands should do more. At minimum, it should limit or reduce its greenhouse gas emissions by 25% by the end of 2020, it was said then. And it showed there what roles international or domestic courts can play in this precise field. Similarly, cases have been used to address issues there of the responsibility of companies. Private actors should similarly be held to account for not complying with international environmental agreements. So we've seen cases being brought, for instance, in the UK against Shell, of that they should be doing more to reduce greenhouse gas emissions. We also have seen other type of cases like greenwash cases, which deals with advertisement of luring consumers to elect or choose that company because, for instance, they say they're carbon neutral. While the reality is far more complex, and that is not being portrayed by such advertisement. So overall, there's a whole bunch of different cases that are going on there. Now, why this year is the year in the context of the role of international courts and the issue of environmental law, as it never happened before, that not only do we have such an influx of domestic cases, we actually have an advisory opinion pending at the International Court of Justice. International Court of Justice has been conservative, at least, of dealing with issues of international environmental law. Now they have been directly asked by an initiative led by Vanuatu, supported by 130 other states, to clarify what are the legal obligations under international law related to climate change and the respective responsibilities there, particularly of global north states towards, for instance, the least developed or small island states. It's still pending right now. Issues are, we expect that they're gonna wait it out for the other two advisory opinions, because we have more. We have the International Tribunal for the Law of the Sea, who has similarly been asked by small island states, namely the Commission on the Small Island States on Climate Change and International Law. A variety of small island states, including again Vanuatu, have asked the International Tribunal for the Law of the Sea what is the applicable international law and rules of the law of the sea on issues of climate change and the respective responsibilities coming from it. Again, it's a momentum case, and it hasn't happened in the past that both courts have pending their authoritative interpretation on applicable rules. Now, on the last, and time won't permit me to go further into this, is that we have similar movements in the context of the regional human rights courts. The European Court of Human Rights has 3 major climate change cases pending. Tomorrow, judgments will be rendered. In the Klimatseenurinnen versus Switzerland case, which deals with their respective responsibilities towards elderly women as they're more affected by climate change. We have the Duarte Agostinho case that I mentioned before on dealing with the youth, and another case there as well. And the Inter-American system similarly has an advisory opinion pending on issues of climate change there. In that, what we see is that the momentum is there of defining what is there, the rule of international law, how is international environmental law shaping, and how can we actually better address issues of climate change? How can we hold governments to account? Regardless of how these opinions come out in the coming weeks and months ahead, one thing is clear: collectively, they all will help determine whether international obligations of states create indeed tangible steps towards achieving the goal of 1.5 degrees Celsius. As always, the law will not enforce itself. Citizens around the globe, and especially those living in the high industrialized nations and those who are not yet feel the harm of climate change in any personal direct way, should push their governments further to live up to the obligations and that the courts announce. In other words, to sum up, interesting times where we're at, where we really can see how international courts are used for a vehicle of change. I look forward to hearing any questions you have at the end of the presentations.
All right, thank you so much, Marjolein, for that very interesting presentation. We now have with us our second speaker, Stephanie Lalishelu, who I will now give the floor to.
Hello, everyone. Apologies for being slightly late. Good morning, good afternoon. I'm not sure what's the best thing to say, so it's very nice to be here. Thank you for having me. If you could give me a second to try to find my presentation so that I can share it with you, or if you have access to it, then it's fine as well if someone wants to share it, but just give me a second and I will find it. Marjolaine, I'm very sorry because I haven't been able to listen to what you were saying. I was on the move and I wasn't able to connect via any portable device to be able to listen to you. However, I had read your slides, so I think I know, and I think that whatever we're going to say is quite, well, goes in the same direction, so that's very good. And I would probably leave it from where you left. Well, I would probably take it from where you left it right now. So now let me share my screen and let me know if you can see my screen. Yeah, can you?
Can't see. Oh, that's perfect.
Yeah, can you now? Okay.
Yes.
So let me start the slideshow and okay. Thank you very much. So what we had agreed with Marjolaine is that following the analysis, the thorough analysis of the role of international courts in times of conflicts and turbulent times that Marjolaine has offered you, we had agreed that I would focus then on the European courts, which are slightly different in the sense that they are international courts as well. But at least for the Court of Justice of the European Union, that one belongs to a separate legal order, which is not the international legal order. So we thought it would have been interesting to also paint that broad picture. So I'm going to focus on the role of the European judiciary and explain to you what I mean by that. And in terms of crisis or conflict situation, I'm going to focus on the rule of law crisis and how to uphold the rule of law. So what I propose to do is to consider the role of judges in upholding the rule of law, first of all. And also by looking at two European courts, as I said. So the first one is the European Court of Human Rights, and the second one is the Court of Justice of the European Union. I will introduce them in turn. Consider some extent or some examples of judicial activism, which means that the courts are going beyond basically the judicial role, and instead of exercising a certain degree of restraints, sometimes exercise a certain degree of activism. Especially rule of law is a good example of such judicial activism. And to explore what I'm sure has already been touched upon in a way, it's the idea of responsive judicial review, which is that judges that do not actually operate in a vacuum, and the contextualization of the problematic is very important, as well as what we call judicial dialogue, so dialogue across courts and legal systems. But let me first introduce you very briefly to the framework of the rule of law at the intergovernmental level by focusing on Europe. So the intergovernmental level is obviously the UN level, but also the Council of Europe level for Europe. So the start point doesn't change. The start point is the end of the Second World War, or even before that. And at that point, there was a need to create a modern international legal order. So you are probably already familiar with the Charter of the United Nations of 1945. But maybe what you hadn't really paid attention to until now is the importance it actually gives to the rule of law together with fundamental rights. So upholding the rule of law is obviously a very important tool in order to maintain peace. The UN in the Charter has what we call a broad or thick approach to the rule of law, which is that, as I said before, it doesn't look at the rule of law only in procedural terms, but actually in substantive terms, and associates the rule of law with peace and security and the respect for human rights, as well as the fact that states, signatories to the Charter, are actually bound by international law while respecting their sovereignty. And the role of the rule of law was more, let's say, more expressly set out later on, not so long ago, about 12 years ago, in 2012, via a declaration of the high-level meeting of the General Assembly on the rule of law at the national and international levels, which comes and reinforce the importance of the rule of law at the international level and at the UN level. Now, the European level is quite similar. If you look at the constitution of the Council of Europe, so this is the intergovernmental regional forum and body to ensure peace and security, as well as the rule of law and democracy in Europe. So the Council of Europe has a specific reference, particularly via the European Commission for Democracy through law, which is otherwise called the Venice Commission, whereby the rule of law is clearly associated to the protection of human rights and the protection of democracy. So rule of law, human rights, and democracy are the triangle, if you want, foundational triangle of the Council of Europe, particularly when it comes to its institutions, including the court. So this is the framework in Europe to uphold the rule of law and provide justice, particularly in turbulent times. Now, in the Statute of the Council of Europe, there is a specific reference to the rule of law, human rights, and democracy, as well as in the Constitution of the European Court for the protection of human rights and fundamental freedoms. So, as well as in the European Convention on Human Rights. So this is very important in the sense that all those documents are aligned with each other, and they form the foundations of those three pillars that we spoke about before, which is the respect for human rights, a pluralist approach to democracy, and the rule of law, which are at the core of the Council of Europe. So again, this is a thick approach to the rule of law in the sense that it's broad and it is not limited to the way the court operates, for example. Now, I'm sure that you saw in the first half of the webinar some of the limits of enforcement via intergovernmental instruments at the national, regional, and international level. And the same applies within the Council of Europe and in Europe. This is why it's very interesting to look at the role of the courts, which we will do in a second. But before we look at the role of the courts, I need to tell you a few things about the rule of law, again in Europe, but this time at the supranational level in Europe, which is the European Union, which is, of course, different from the Council of Europe, and we are going to compare them in a short while. So, in the European Union, we have a separate, let's say, legal order, which is the EU legal order. And the EU legal order is actually based on specific foundation treaties. So one is the TEU, the Treaty on the European Union, and the other one is the Treaty on the Functioning of the EU, which is the TFEU. Very briefly, I'm just going to refer to a couple of very core articles, foundational articles that are of importance here because they explain the role of the court. Article 2 of the EU Treaty, which sets out the values, the European values, the values on which the Union is founded, And you can see in those values, you can find, of course, the respect for human rights, but also for rule of law, as well as non-discrimination, dignity, and respect for minorities. So this is a very important article. To be taken into account together with Article 6 of the EU Treaty. Article 6 is the human rights provision. In other words, it discusses the importance of the EU instrument, which is the EU Charter of Fundamental Rights, which you have here on the right side of your screen. But it also refers to the ECHR and the European Convention for the Protection of Human Rights and Fundamental Rights that we spoke about just before. So there is a recognition that we have two very important instruments on the protection of human rights, fundamental human rights in Europe, and these are the EU Charter and the ECHR. At the moment, the EU is not signatory to is not a party to the convention. And however, Article 6 of the TEU specifically provides for this to happen. So if you look at paragraph 2, you will see that it is provided that the Union shall accede to the ECHR. So this is ongoing work. There were attempts, but they were failed attempts, and therefore the two systems continue working hand in hand in the meantime. The last article that I wanted to very briefly introduce, it's Article 7 of the TFU and that on the TEU, and that one is well, something that probably is very difficult to visualize or to realize its potential power. It's an article that actually provides for the possibility of sanctioning EU member states if they do not actually uphold sufficiently human rights, fundamental human rights, and in particular, if they are found in serious violation of human rights. And there is a whole process that should be followed in that case. That article has been referred to as the nuclear weapon in inverted commas, simply because it would be it is a very difficult article to apply, simply because it means that you need to have, a consensus at the EU level across most of the member states or all of the member states. A specific member state is actually in breach of that article, and that, of course, is very difficult in itself. So it's a very demanding procedure which remains largely underused. It is more used as a political threat, if you want, which means that in the meantime, the role of the EU institutions, particularly the European Commission, but also the Court of Justice of the European Union, is reinforced. So for you to understand, I have created, first of all, a couple of slides on understanding the EU, and then we will compare the EU to the Council of Europe for you to understand. Now, very briefly, historically, there is a difference between what we call intergovernmentalism and supranationalism. So intergovernmentalism is very much what is in existence in the international legal order, whereby the states, the nations, are the ones that are driving and agreeing on the content of the international legal order. However, supranationalism is different in the sense that in the example of the European Union, which is probably the example of the most advanced supranational international organization, the nations, in that case, the EU member states, they have agreed to pool some of their sovereignty to the EU. So they have agreed to transfer sovereignty to the EU. And this is why we call it supranational, because it's above the nation. Not for everything, of course, but it remains above the nation for quite a lot of aspects of daily affairs. So how did this start? This started again. The starting point is the same, it's the end of the Second World War, at the point that international organizations were being created, whether it's the UN, whether it's NATO, whether it's the Council of Europe and others. And at this point, the EU was initially created under the Treaty of Paris in 1951, as a way to counter the major distraction of Europe, and also try to ensure that peace and prosperity would prevail and would probably also minimize the risk of having another confrontation, another conflict in Europe. So the European Coal and Steel Community was created. As I explained before, it's based on supranationalism and not on intergovernmentalism. And this is the very beginning of EU law. It's a community of states in Europe. After which, 1957, the key dates for the European Union, because it's the treaties of Rome that were actually signed, and one of them creates the European Economic Community, the EEC, which later became the European Community, EC, and now it's renamed the EU since 1992. But also the Euratom Treaty, which is the European Atomic Energy Community. So these are the founding treaties of the European Union. And out of those founding treaties and out of the case law of the Court of Justice of the European Union, which was created very early on in 1957, together with the Commission, the Council of Ministers, and the European Parliament, although they didn't really have the same powers and the same shape as they have today, the unique features of the EU became more and more obvious. They became more and more well, overt, let's say, and they were formulated, articulated. So the unique features of the European Union as they are today appear on the left side of your screen. The first one is the one I mentioned already, which is the transfer of sovereign powers from national parliaments to the EU and its institutions. In other words, the vast majority of decisions are made by majority voting at the EU, and the vast majority of legislation that is applicable in the national parliaments, that is discussed in the national parliaments, originates from the EU. The principle of supremacy or primacy, which is that the laws emanating from the EU are actually belong to the member states' own laws, and they prevail over the member states' own laws. EU law, so the law of the European Union, if you want, EU law, is automatically part and parcel of the legal system of each member state, and therefore can be relied on before national courts. Of course, there are exceptions, or depends on what type of EU law it is, if it's primary or secondary legislation. But nevertheless, they are part and parcel of the EU national, of national systems. And finally, for us, this is perhaps the most important one, the European Union has its own enforcement mechanism that can be said to be quite effective. I already presented to you Article 7 of the TEU. I didn't say that that one was effective because I said it was underused, but we are going to see how enforcement mechanisms within the Union are actually made effective. So this is very important because there is no EU constitution as such, but we can say that the principles of the that we have set out and emanate from the Treaty on the European Union are the kind of fundamental constitutional provisions of the EU. So the last thing I wanted to say about intergovernmentalism and supranationalism, for you to understand how it is different in the European Union, is this simple slide, which is taken from a specific source, which is mentioned here. And it shows you the situation. So in orange, the intergovernmental pillars, if you want, in the European Union, and in purple, the more supranational pillars of the European Union. And you can see that with the latest reform of the European Union, which is the Lisbon Treaty of 2009, there was a pooling of sovereignty towards the supranational level, as you can see. So it's very important to understand then the role of the court and to understand, how enforcement mechanisms function. Nowadays, the only pillar that remains primarily intergovernmental is the one of the common foreign security policy. That is the one. All the rest is largely supranational, and that includes criminal cooperation as well. So just to summarize what we said, when we come to the Council of Europe and the European Union, they don't have the same number of member states, 46 on the one hand, 27 on the other. One is an international organization, based on intergovernmentalism. The other one is a supranational organization. The Council of Europe has the European Convention on Human Rights, whereas the European Union has founding treaties plus the EU Charter. The Council of Europe has its own court, which is the European Court of Human Rights, to which we're going to turn now, whereas the European Union has the Court of Justice of the European Union. By the same token, the Council of Europe has at its disposal intergovernmental enforcement mechanisms across Europe, whereas the European Union has supranational enforcement mechanisms within the Union, and this is quite different. According to the convention, to the ECHR, to execute Strasbourg court judgments, in other words, court judgments from the European Court of Human Rights, the judgments are transmitted to the Committee of Ministers of the Council of Europe, which issues the obligations of the states, and you have the obligations that can be issued on the states on the left-hand side of the screen. The first one is to pay compensation. This is called just satisfaction. The second one is the adoption of general measures by that specific state, could be amendment to legislation and so on, which means that the redress is collective and benefits the whole society. And the third one is to adopt individual measures for a specific group of individual or group of individuals beyond what exists at the national level. So these are the main redresses available under the convention. And to be noted that the convention offers via Article 46 of the ECHR of the convention the binding status of the judgments of the courts towards that specific state that is at stake in the judgment. And that under paragraph 4, there's a possibility to go back and see if that state is not complying properly, then there's a possibility to go back to court. So this is more or less how it works at the Council of Europe level, whereas in EU law, we have a number of other mechanisms. Before I turn to the more detailed mechanisms, I wanted also to raise the issue of the fact that some states are not complying systematically, whether it's with judgments of the Strasbourg court or whether it's with judgments of the Luxembourg courts. Plus, we have a phenomenon of leaving international organizations, whether it's the Council of Europe with Russia, or whether it's the EU with the UK. Of course, they did not leave for the same reason, but nevertheless, this is a problematic when it comes to enforcement. So just to give you a bit of background again, at the Strasbourg courts, at the European Court of Human Rights, the cases can be brought by individuals against their own states or between states, or it could be by individuals against another state as well, which is very important because it gives the voice to the individual who usually is the victim of the violation of human rights. So that's a very important element, that the Strasbourg court is able to hear individual applications. As we said before, the convention is an instrument of collective enforcement of human rights and fundamental freedoms, which is also very important when it comes to understanding the role of the Strasbourg court. There are opportunities for third-party interventions under the convention. And of course, the variety, the diversity of societal issues that actually come to the court is absolutely amazing. However, to be able to get to Strasbourg, any applicant must first of all exhaust all domestic remedies at the national level, which can become problematic, especially in times of conflict. There is a possibility for friendly settlements under the convention, as well as for judicial dialogue as well. In the EU, the Court of Justice of the European Union is the guardian of many different articles and many different procedures. You have them on the right-hand side of the screen. But the most important article for our purposes today is Article 19 of the TEU. Why is that so? Because Article 19 of the TEU is the article that sets out the role of the court itself. You remember the TEU is like the fundamental treaty of the EU. So it sets out the fundamental role of the court. Particularly, it sets out that the court can rule on actions brought against member states, against EU institutions, or a legal person, and that those cases are binding upon all of those people, all of those institutions. The Court of Justice of the European Union can give preliminary rulings at the request of national courts. This is when the court interprets EU law or issues a ruling on the validity of EU acts, and this is Article 267 of the TFEU. And also Article 19 sets out the obligation of member states to provide effective remedies in the fields covered by union law. And this is very important when, especially in times of conflict and in times of turbulences, and you will see why in the next slide. In addition to Article 19 of the EU, the TFEU, the Treaty on the Functioning of the European Union, gives a long list of possible direct and indirect actions. So we have already seen 267 of the TFEU. That's for indirect actions in the sense that the court is the only court body that can interpret EU law. And also decide on the validity of EU acts. But in addition to that, we have Article 258 of the TFEU, which concerns the failure of member states to fulfill obligations, and that action can be brought by the European Commission. This is quite common. Article 259 of the TFEU, again, on the failure of a member state to fulfill obligations under EU law, but this time that action can be brought by another member state. Again, it's quite common. Article 260 of the TFEU explains what the court can do. Particularly, it can impose penalties against a member state that is found in breach of the provisions of the treaties. Article 263 of the TFEU is the direct action by excellence, is the review of legality of EU acts, those that are intended to produce legal effects vis-à-vis third parties. So it's quite broad. And there are a number of privileged and non-privileged applicants that can bring such an action, including individuals, in specific cases, however, which can lead to the annulment of an EU act, to the EU act being void. We also have a provision for failure to act by the EU institutions under Article 265 of the TFEU, and which means that in such a case, the EU institutions are obliged to take the necessary measures to comply with the said judgment. So all those mechanisms are available, and they are used, of course, at the court level. The case law of the Court of Justice of the European Union within the Union is authoritative, so it's much more than simply addressed to a specific institution or a specific state. And there are other principles that are very important. One is direct applicability of EU law in the member states. We discussed it before. The direct effect of specific provisions of EU law, the indirect effect, or the harmonious interpretation of EU laws. In other words, all member states, particularly the parliaments, but not only, must make sure that they go also not only by the letter of the law, but also by the spirit of EU law. There is an obligation of sincere cooperation amongst the member states, and the principle of subsidiarity, which exists also in the Council of Europe. But in the EU, the principle of subsidiarity is more complex in the sense that you need to have a look at the competencies. So what competencies have been pulled to the EU and what competencies remain to the member states. Once you know all this, then you're able to look at the role of European judges in times of conflicts, particularly looking at upholding the rule of law in Europe. And I chose for today the principle of judicial independence. Why did I choose that principle? Because without judicial independence, full judicial independence, there can be no effective rule of law protection. And both European courts have landmark case law on judicial independence. This case law for both courts has always existed, but in the past 10 years, it has really come to the forefront. So we start with the Court of Justice of the European Union, whereby in the context of the financial crisis, had to review quite a lot of aspects of what makes the judges independent, which also includes their remuneration and their tax status. And in that very famous judgment of ASJP, the Court of Justice of the European Union very clearly said that every member state must ensure that the bodies which as courts or tribunals within the meaning of EU law come within its judicial system in the fields covered by that law, meet the requirements of effective judicial protection. So the court here creates what we call now the EU judiciary. It means that not only are the Court of Justice of the European Union and the General Court, EU courts, but the national courts are also part of that wider nexus of EU judiciary. So the EU moved from the mere effective judicial protection principle that is enshrined in Article 19 of the TEU that I read to you to an actual implementation of judicial independence for the whole of the EU judiciary. So we have a number of high-profile cases that assess the extent of the independence of the judiciary in specific member states. And the other thing is that Article 19, as interpreted by the Court of Justice of the European Union, doesn't have to do with whether member states are implementing EU law or not. Article 19 applies whether member states and their courts, in fact, are implementing EU law or not. So it's very broad interpretation. If you want to know more, I have a working paper on that with Jacqueline Veraldi. You can find it here. So just to make it very short, because we're running out of time, from then on, the Court of Justice of the European Union established a general obligation for EU member states to guarantee and respect the independence of the national courts and tribunals via the interpretation of Article 19, paragraph 1 of the TEU, second paragraph, but also third subparagraph. So a member state can be found to have failed to fulfill its obligations under the treaties by violating the principle of judicial independence via several mechanisms. The first mechanism is the one we saw in the previous slide, which is the infringement proceedings against Poland, as an example, under Article 258 of the TFEU, brought by the European Commission, alleging an infringement of Article 19, paragraph 1 of the EU Treaty of this, and the second subparagraph, which is the one we mentioned before. So there are a number of high-profile cases against Poland in that sense, because of the way Poland reformed the judiciary in the country. So since then, there is a proliferation of cases raising different issues of judicial independence from national courts in many EU member states, not just Poland, under Article 19 of the EU Treaty, which requires, as I said before, both arms of the EU judiciary to be independent, not only the supranational arm, but also the national arm. And as I said before, it's more interesting to use Article 19 of the EU Treaty, because under that article you are not limited via the application of EU law or not, whereas the EU Charter, for the violation of a provision of the EU Charter to be argued, you need to actually show that you fall within the scope of the application of union law, which is not the case with Article 19. So, as we stand today, fundamentals and the fundamental or essential guarantees of judicial protection in the EU include the irremovability of judges, the commensurate remuneration vis-à-vis austerity measures, particularly, as I said before, it started with that. A real reduction of salaries of judges poses a serious threat to judicial independence and is usually not permitted. The protection from external intervention or pressure in appointments, term duration, remuneration, and measures that can appear to be discretionary or arbitrary, because they may be based on political decisions or on power struggle, or even as a result of Brexit, when the Advocate General of the Court of Justice of the European Union was terminated because of Brexit. So this is the broad picture of the Court of Justice of the European Union, and the more case law there is, the more those essential guarantees are becoming hard law, and they have to be enforced. And I will explain to you how they have to be enforced. But just to say that this is also in line with the case law of the Strasbourg Court of the European Court of Human Rights on the independence of the European justice system. Again, there is crucial case law in Strasbourg about it. Against Poland, also for its reform of the judiciary that I mentioned just before, particularly the National Council of the Judiciary, under the influence of legislative and the executive powers in the appointment of judicial members, but also the disciplinary measures against judges, which the court in Strasbourg has found on quite a few occasions as creating fundamental irregularities due to the successive reforms and systemic risks to judicial independence. Article 6, paragraph 1 of the convention has been used, which is around the right to a tribunal established by law or the lack of access to a court. And in that aspect, the European Court of Human Rights has actually even referred to a general trend of trying to frame judicial independence, and has also referred to the case law of the Court of Justice of the European Union, specifically for the Polish judicial system. Article 10 of the convention has also been used in some cases, so on the right to freedom of expression of the judges themselves, but also Article 8 of the Convention on the Right to Respect for Private Life of the judges themselves. So there are quite a few aspects that are covered here, and there are many more, including statutory independence, absence of outside influence that we saw before, as well as objective guarantees as to the career of judges. So I wanted to finish by going back to a case of the European Court of Human Rights, which is a case against Hungary, of the Grand Chamber of Baca versus Hungary, where the court found a violation of Article 6, paragraph 1. As I said before, the right of access to a court means that the judges cannot be unduly restrained. And in that case, there was no process of judicial review available due to the constitutional change of the court system in Hungary, with the creation of the Cura, the new Supreme Court, the highest court in Hungary, and the replacement of the previous Supreme Court. So that is again a landmark case. And in this conclusion, the court actually notes the growing importance which international and Council of Europe instruments, as well as the case law of international courts and the practice of other international bodies, were attaching to procedural fairness in cases involving the removal or dismissal of judges, including intervention by an authority which was independent of the executive and legislative powers in respect of every decision affecting the termination of the judge's office. So it shows you that the two European courts are aligned in their case law. They have different tools to do so, but they are aligned. The last thing I wanted to say is that, and this is something perhaps I should have picked up here, the only perhaps main difference is that in the EU, you've got one more way of enforcing the case law of the court, which is the rule of law conditionality mechanism, which is a mixture of case law from the Court of Justice of the European Union, opinions of the European Commission, reporting on the member states, on the status of the rule of law in the member states, and the application of a new EU regulation on the rule of law and conditionality, which actually has been used against Hungary. So in that sense, perhaps the enforcement of the case law is harder at the Council of Europe level than it is at the EU level. But the challenges are the same, and they are being addressed quite responsibly and quite thoroughly in Europe to try to give an answer to the backbone of the rule of law in times of conflicts.
So thank you so much for your time, everyone. I wish you a lovely day, and we hope to see you soon.